Hey, welcome once again, Employment Law Show. So good to have you along for this next 30 minutes. John Scholes here. Beside me, of course, Lior Samfiru, co-founding partner, Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. You want to reach out when the show is done any other time to Lior and his team? Easy. 1-855-821-5900 would be the phone number. Online for email, help@employmentlawyer.ca, and the website we always like to put out there every show and talk about it all the time. We use it during the show as well, pocketemploymentlawyer.ca. It's free, it's anonymous, and it is a wealth of employment law knowledge built just for you to use anytime. Really simple as well. On the show today, Lior, facts about termination process. We're going to take you inside the world of employment law with some facts about the termination process in just a bit. But we always start with the situation that you've been working on recently, the week that was. What do you got this week, pal?
John, it's been a whirlwind. I mean, I swear to God, over the last 2 years, it's been a whirlwind. And I kind of always think, well, okay, I think it's going to get normalized a bit. It's going to go back to the way things were pre-pandemic for me and my office and my team. But we continue to be busy. We continue to field a lot of questions, a lot of issues to solve. And we help a lot of individuals, which is always a privilege with respect to their workplace rights and workplace problems. Things have changed for many people. There's very few of us that are doing the same work in the same way as we did it 2 years ago. So if your job has changed, if you lost your job, if you're facing an ultimatum, a vaccine policy or mandate, whatever the issue, guess what? The law does provide options. The law provides recourse. We have excellent employment laws in this country. If you think we don't, it's probably because you don't realize what the law does and what the law provides for you. So it's easy. Make the call. Let's talk about what your situation is. Let's try to help you and solve that problem. Throughout the show, we'll give you that contact information so that you can reach out to me directly and we can discuss your problem and outline what the options that you have. We cover a lot of things on the show, and we will today as well, but we can't always get to everything. So if your issue is not covered, if you still have questions, or maybe you don't even realize you had a question until you heard us say something on the show, easy, reach out after the show, phone or email. Throughout the show, you'll see that information. Very easy to contact me, and I look forward for you to do that. But now that we know what we're here to do, let's do it. One of the main questions I've been fielding over the past number of weeks, John, has to do with returning back to work. So now that a lot of businesses, governments, individuals have decided, okay, we need to try to move past this pandemic. We need to try to get back to some semblance of normalcy. A lot of employers are saying, okay, I want you to come back and work in the office. Many employees have been working remotely for a long time during the pandemic, either full-time or part-time. And I've been seeing a lot of employers saying, come back to work. Okay, I need you to be back to the way working the way things were pre-pandemic, in the office, 9 to 5, or what have you. So let's talk a bit about that. Let me outline what this means. Ultimately, if you were working from home, but it was clear that this is only during the pandemic, it was clear that it's only for a definite period of time, your employer does have the right to say, come back to work. They do have a right to do that. And ultimately, if you don't, that could be considered a resignation. But there's a number of important things to keep in mind. For example, your employer still must take all precautions to avoid the pandemic and to ensure workplace safety. They must follow government regulations with respect to distancing, masking if that's still there, vaccination if you're working in an industry where there's a vaccine mandate. So your employer can't just ignore the pandemic. They have to still ensure that the workplace is safe, contact tracing, what have you. So that's important. The pandemic is still here, and employers can't disregard it and pretend it doesn't exist. The other thing to keep in mind is while you're working from home, maybe, and I've spoken with many individuals, maybe you've decided to keep your kids home, maybe you've been homeschooling them. Well, now, if your employer is going to want you to come back to work, you're going to have to find other childcare arrangements, either babysitting or school or daycare. And that may take some time. So you may not find childcare immediately tomorrow. So your employer does have to accommodate you and give you that time that you need to find childcare. They can't say, well, that's your problem. You're back at work on Monday. If it's going to take you several Mondays to find childcare, that's legitimate. Say that to your employer, put that in writing. They are under a legal obligation to accommodate. So very important things. If you do have questions about going back to work, if you're not sure your employer is doing it the same, And by the way, just because you're going back to work doesn't mean your job can be changed. You're still expected to go back to the same job at the same pay, location, and the same responsibilities. If that's not your situation, that could be a constructive dismissal. So certainly a lot to discuss if you're going back to work. If you're not sure if your employer is doing it the right way, you know what to do. You reach out to me and we'll have that discussion.
Lior, does that change in the scenario, saying, and you and I both know people that have done this, early on when the pandemic looked like it was going to be around for a while, they packed up and moved, went 100K away from where they currently were residing at that point, and now they're getting called back to work. Now they got to get to and from work from much further out than they used to be. Do they have any leeway in that regard, or the employer's going to say, that was your fault, not mine?
That could absolutely be a problem. Now, if your employer said, yeah, it's fine, go ahead and move because you're going to be able to continue working remotely, then that's fine. And your employer can't just change their mind. But if you decided to do that without checking with your employer that that's going to be okay, you decided to move, and now your employer is saying come back to work, yeah, your employer can expect you to come back to work even though you've chosen to move further away. And if you don't come back to work, you may say, well, now it's going to take me 3 hours to get to work. I don't want to do that. Despite that, that could be considered a resignation. So if you're going to move, check with your employer what the long-term plans are. Confirm with them they're going to be able to continue working remotely. If they say that's fine, confirm that in writing. And then in that point, John, they can't just change their mind.
Radio shows, we've been doing those for a decade. Lior and I and the rest of his team at the firm. You want to find a radio show, listen to it, tune in every week, whether it's a half hour or a full hour. Simply go to employmentlawyer.ca on the media tab and you'll find a list of stations where you can catch us pretty much across the country. And during those shows, of course, we take a lot of live phone calls, tons of great questions you give us every week. I want to play back our first phone call, Lior, from the radio show, and you and I will talk about it. What do you say?
Do it.
I work for a professional services company. I've been there for now 20 years. I'm in my late 50s, and they're now requiring everybody in the office to sign employment contracts. Wording in there that they limit it to whatever the ESA minimum. Just want to know what my rights are. Am I required to sign the employment contract, or what's the repercussions if I don't?
Answer like this.
Good question. And he is smart. Yeah, exactly. The answer is no, just don't do it. No. Walk away, for sure. But I think I need to explain why that is. First of all, he's extremely smart to be concerned about this. And all of you should be concerned if your employer walks in one day and wants you to sign a new employment agreement. Because guess what? What it probably does, just like this individual said in his call to us, is that it tries to limit future severance. It's one of the main reasons why employers want to use a new employment agreement, because they realize, wait a second, if I ever let this employee go, I'm going to have to pay them a lot of severance. How do I reduce that obligation? I know. Let them sign an employment agreement limiting their severance, and that way if I let them go, I saved a bunch of money. So if this guy were to sign this employment agreement and then he was let go, he's been there for 20 years, he could be owed as little as 8 weeks' pay. That's if he signs the agreement that limits his severance. What happens if he doesn't sign and then he is let go? Well, to see how much severance he's owed then, let's actually go to pocketemploymentlawyer.ca. Let's use our severance calculator, and let's actually see how much severance this guy would be owed if he didn't sign the employment agreement. So he's 57 years old. He's been there for 20 years. That's a long time. Severance for him, if he didn't sign the agreement, is as much as 24 months' pay. Somewhere from between 18 and 24 months' pay. Now, John, if he signs the agreement, 8 weeks' pay. That's 2 months. If he does not sign, as much as 2 years' pay. Now, you tell me, should he sign that employment agreement? I think the answer is
absolutely not.
Absolutely not. You cannot be let go without severance if you don't sign. You're better off saying thanks, but no thanks, even if it means you lose your job, because at least then you get full severance. So keep that in mind, and if you're not sure what to do, what it does, what it says, give me a call.
Again, really smart phone call. Those come in all the time. Employmentlawyer.ca to catch a radio station where you can ask Lior questions every week as well. But terminationquestions.com is yet another free and anonymous website for you to do exactly that. Ask questions about employment law. This one right now comes from Roland Lior. Roland writes in, says, I resigned from a position I held for 7 years to join a new company that had recruited me. After only 4 months, I was fired for not being a good fit and given 2 weeks of severance pay. Do I have any options here?
So very actually common question, much more common situation, John, than you think. Someone is recruited from another job. They're not necessarily looking to leave, but someone knocks on their door and convinces them to move. And you know what? As things happen, it just doesn't work out. It doesn't work out. No one's being a bad person. It just didn't work out. So they lose their job with the new employer. But here's the important part of this. If you are recruited away from another job, it's a secure job, you're recruited away, and then things don't work out with the second company and you were let go, you're going to be owed enhanced severance. We call this inducement. If you've been induced to leave a secure job only to then be let go, the severance that you're going to be owed is going to consider the time that you had with the previous employer. So in this case, he had been with that company for a few years, with the new company only for a few months. The new company may say, well, we're only letting someone go that's been with us for 4 months. That's not a big deal. We'll pay him a couple of weeks' pay. First of all, John, even if he had only worked for them for 4 months, he'd be owed a lot more than 2 weeks' pay. Okay? He could be owed several months' pay. But because he was induced to leave another job, he's owed even more severance than that. He could be 2, 3, 5 times what he'd be owed otherwise. So very important always to get legal advice if you lost your job. I don't care if you worked for a day or 50 years. It's that much more important to get legal advice if you were recruited away from another job and then you were let go, because your entitlements are going to be a lot more than you realize.
And again, this speaks to the fact that you always say how important the employment agreement is, and if you put on your employer hat, they could avoid that by saying, we do not recognize previous service, blah, 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 right? Reduce that amount. Save them some bucks, right?
An employer would be wise if they're recruiting someone to make it clear that we're not going to recognize past service and to have a term that limits severance. For an employee, if you're going to leave a secure job to join another company, number one, you don't want to agree to a probationary period, right? Why do you agree to be on a probation period when you're leaving a secure job because they convinced you? That's number one. Number two is you don't want to agree to something that limits your severance. So very important to pay close attention to that employment agreement always, and especially if you're leaving a secure job.
Where are we going next? Facts about the termination process, but first we'll take a short break. We'll get into that now. The number in the meantime, 1-855-821-5900. Email help@employmentlawyer.ca. We'll continue in the Employment Law Show. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Thanks for hanging in. Employment Law Show. We're going to continue here. As mentioned, facts about the termination process. Let's get into this, Lior. There's a few people are not going to know this stuff necessarily, which is why we do this stuff every week. Important things you need to know about the employment rights, which are quite robust for you, especially when you learn about them on this show right in our radio shows. Number one is this, Lior. You can be fired through any method, email, virtually, in person, over a phone call, a couple soup cans with a wire. Doesn't matter, right?
By owl, maybe? Yes.
Whatever.
The law really does not require your employer to let you go in a certain way, as long as you also have something in writing ultimately, which you always will. Obviously, let's face it, it's completely demeaning, I guess, if you're let go just over the phone or over a Zoom call. But that doesn't necessarily make it illegal. We've heard some stories in the media recently with some major companies where they let go a bunch of people in like a mass Zoom call. Not the way I would recommend doing it. Not a good way to do it, but also not illegal. There's no law that says you have to be let go in a personal meeting in a boardroom. A lot of employers are going to choose to do that out of respect and to ensure confidentiality and to ensure privacy, but they don't actually have to. You can be let go other ways. and ultimately it's not something that you can do something about. So I wouldn't necessarily worry too much about that. The issue, is we're going to talk about in a minute, is always what is it that they're offering you financially? Are they offering you the right amount? Spoiler alert, they're probably not. But in terms of how you're let go, the form doesn't so much matter. If you're let go in writing, over the phone, text message, again, not cool, but also not illegal.
All right, fact number 2 about the termination process, Lior, is this: your employer cannot force you to resign. How about that?
Now, we're talking about resignation in the context of a termination consideration, because a forced resignation is, in fact, a termination. If your employer says to you, you have no choice but to resign, well, what are they doing? They've decided you're not going to work there anymore. If they've decided that, that's a termination. Even if you're the one saying, okay, well, if I don't have a choice, here's my letter of resignation. No, a resignation, for it to be actually a resignation, you have to be doing it voluntarily. You have to do it unilaterally. You have to make the decision. No one can make the decision for you. If someone made the decision for you to resign, to leave, that's no longer a resignation, that's a termination. And the reason we have to distinguish between a resignation and a termination is, of course, severance. With a true resignation, where you've decided, I don't want to work here anymore, I want to go do something else, and you resign, yes, you're not going to be owed any compensation, any severance. You get paid to the last day of work, you get paid your outstanding vacation, and that's it. But with a forced resignation, where you've resigned because someone said you had to, or someone didn't give you a choice, well, that's a termination, and now you are owed severance. That could be as much as 2 years' pay, 24 months. So when your boss says, I'll expect your resignation in the morning, well, first of all, you can say thanks, but no thanks, I'm not resigning. But even if you resign in that scenario and you can show that that's what you've resigned, it's still a termination, and your boss, your employer, cannot avoid paying you severance just because they used the word resignation.
Another number 3 termination fact is this: you do not have to sign that termination letter on the spot, even though you may be asked to, right?
Absolutely not. So first of all, a smart employer is never going to ask you to sign on the spot. Can you imagine? You're not leaving this boardroom unless you sign. What is this? Spanish Inquisition? I mean, no, you can't do that, right? That's not legal. It's improper, and in fact, could be in a way, a criminal act if you're essentially locking someone in until they've signed. So a very bad way of doing things. But beyond that, you don't want to, even if you had the option, you don't want to sign it, period, until you've gotten some legal advice, because chances are, and we talked about that a couple minutes ago, that the amount that they've offered you, even though you may think it's okay, is likely a lot less than what you're owed. It could be 2 months less than what you're owed. It could be 18 months less than what you're owed. It's probably a significant amount. In 90% of cases, that termination letter provides for less than what you're owed, because either the company may not appreciate how much they owe you, or they hope that you, the employee, don't appreciate how much they owe you, and they hope they can get away with it. And unfortunately, in many cases, they do, because individuals may not know. They offered me 10 weeks after being there for only 4 years. That sounds right, when in fact it could be owed 6 months, 8 months, 9 months of pay. So do the right thing. Do not sign that severance letter until you've gotten proper advice.
Maybe it's not on the spot there and then, but it has the old Friday at 5, we need this back. How about that type of timeline? Because that still gives people stress and panic, right?
Big time, absolutely. So almost every severance letter has a deadline. So we're offering you these 8 weeks pay, but to accept it, you have to sign by Friday at 5 or Tuesday at 5, whatever the deadline is. And if you don't sign it, we're not going to give it to you, and you're going to be stressed out. Well, I want to get more money, not less money, so how can I not sign it? There's a deadline. Look, it's right there on a piece of paper. Nonsense. Your legal rights don't expire Friday at 5. In fact, your legal rights don't expire for 2 years. You're going to get what you're owed regardless of that deadline. You have my permission to ignore that deadline. It's meaningless. Let me give you an example. Let's say I owe you $100. And what I say to you is, okay, I'm going to pay you $40, but only if you sign this by Friday. You're going to look at me like I'm crazy, right? You'll say, well, wait a second. You owe me $100. Why would I sign something to say you'll pay me $40? Well, it's the same thing with severance. In the vast majority of cases, you're owed more than what they're offering. So why would you accept less by signing by that deadline? That deadline is meaningless. get advice, do it right, make sure you do not sign anything until you've gotten that advice.
We'll get to one more termination fact here, and that is you are well within your rights to seek the advice and should of an employment lawyer upon termination. Don't sign it. Take some time. Make that phone call, right?
I'm going to go a step beyond. It's not that you should. You must. Okay?
Yeah.
If there's a time when you have to get legal advice is if you lost your job. And by the way, there's a way to do that even easier than picking up a phone call. Go to pocketemploymentlawyer.ca and use our severance calculator. You can find out in seconds whether or not the offer is good or not. You always have to get your advice if you lost your job, no exceptions.
Again, phone calls from the radio show, employmentlawyer.ca is how you find a radio station near you that carries it. We'll get to our second call for the day right now, Lior.
I'm a truck driver, and I've been told that I got to work in the warehouse to sort, build skids, and stuff like that. That's not what I signed up for. They're giving my route away to other people as well. And instead of being paid for the work because I get paid hourly plus piecemeal, I'm only making hourly when I'm working in the warehouse when I should be out delivery making triple what I could be making.
Well, John, this is a classic constructive dismissal situation, okay? He's, number one, having his job change. Instead of working as a driver, he's going to be in the warehouse. That's a significant change. That's a constructive dismissal. He's going to make less money. His pay structure is also being changed. Instead of an hourly, it's going to be kind of on a piecemeal basis. Well, either way, all those things, either together or individually, result in a constructive dismissal. A reminder, a constructive dismissal is a situation where the terms of your employment are changed in a significant way. You can choose to treat that as a termination and make your employer pay you severance. So keep in mind, your employer is not letting you go. They haven't said you're gone, you're out of a job. They simply said, we're changing your terms of employment. You, though, can make the decision and say that by doing this, employer, by making those changes, it's as if you've let me go. Now severance has to be paid. And the severance, again, can be as much as 24 months' pay. And by the way, John, we mentioned pocketemploymentlawyer.ca. Mm-hmm. One of the tools that we have there is it's a tool that allows you to find out if, in fact, you've been constructively dismissed. So if you're not sure if the change that you're facing is a constructive dismissal, go to pocketemploymentlawyer.ca, use our constructive dismissal tool. It's free, it's anonymous, it's easy to use, and find out if, in fact, it is a constructive dismissal.
Lior, does that change if the employer said, hey, we're changing your duties, but we're not touching your pay. You're still making the same salary, same money, so this is okay. It's no sweat off your back, right?
It can absolutely be a constructive dismissal, even if the pay is not changed, even if the pay is the same. Depending on the changes to your job duties, your hours, your responsibilities, it can easily be a constructive dismissal. So the focus is not just on pay, it's on the job itself. That's why, again, very important to get advice if you're ever facing a change in terms of employment.
Short break, more coming up, so stick around for it. The number 1-855-821-5900, pocketemploymentlawyer.ca. Always go there first, and you can also email help@employmentlawyer.ca as well. We'll continue with the Employment Law Show. People think contractors aren't owed severance. Employmentlawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show, a few minutes to go, and we thank you if you tune in every week, whether you're in Ontario or Alberta or BC. You also have the opportunity to catch our radio show as well, employmentlawyer.ca for a list of stations, one that will be near you where you can tune in every week. We'd love to have you call in too, and in that regard, Lior, let's get to one more phone call from the radio show here in the last couple of minutes.
I'm going through some back issues. Been going on for a while. I just came off a layoff from 18 months. They brought me back, thankfully. I'm scheduled to go into back surgery. I haven't told my employer yet, but I'm a little concerned about taking, possibly 4 or 5 months for recovery. Is there anything that you can suggest for me to help prevent me from having to go through any kind of a legal situation?
Great call.
Very good question and a common occurrence. And there's no reason, John, for him to go through a legal situation because it's quite simple what needs to happen here. All he needs is a doctor's note saying that he can't work until he recovers from this surgery, whether it's 4 or 5 months or even longer than that. His employer can't do anything. They can't give him a hard time. They can't reject that doctor's note. And they have to, when he's ready to come back to work, make all efforts to bring him back to the same position and same job. So as long as he has that doctor's note, legally, he has nothing to worry about. If his employer decides to do something that's illegal, there's going to be significant consequences. There's no reason, hopefully, to think that the employer is going to do that. So the lesson here is very simple, and I've talked about this before. That doctor's note is your biggest shield. It's your biggest asset. Okay, if you have that doctor's note saying you cannot work, that's really all you need. And by the way, you don't have to explain what the medical condition is. You don't have to explain the nature of the surgery. You don't have to give your past medical history to your employer. All your employer needs to know is whether you can work or not. And by the way, when he's ready to come back to work, maybe he's not ready to start his job at 100% yet. Maybe he needs to be working his way back gradually. He needs some accommodation. Well, in that situation, the employer has to accommodate gradual return to work, modified duties, modified hours. So all that comes back to what the doctor says. And if your employer ignores that doctor's note, man, there's significant repercussions. You have to call me right away.
Let's take one more shot from terminationquestions.com. Lior, the remaining time. This one now comes from Karina. Karina says, I'm 64 years old and have worked as an accountant for over 28 years with the same company. I was told recently that they are restructuring and that I would be laid off in 3 months and given a 2-month severance package. Do I have to accept this offer immediately?
So let's give her employer the benefit of the doubt that they're restructuring, they're letting you go for legitimate reason, they're not picking on her. That's fine, that's okay, they're allowed to do that, even though she's been there for 28 years, it's a long time. That said, it comes down to severance. So her employer saying, we're telling you that 3 months from now you lose your job, and then we're gonna pay you another 2 months severance. Now that 3 months counts towards her severance. So really what her employer is offering her here is 5 months, okay, 5 months. So you're shaking your head, you know the answer. I think our regular viewers are shaking their head just as vigorously as you because they know that's not appropriate. So let's, for the benefit of those who may not be sure, why isn't 5 months appropriate? Let's show you. Let's go to pocketemploymentlawyer.ca. Let's use our handy dandy severance pay calculator and let's see how much she's actually owed. So she's a 64-year-old accountant, been there for 28 years. We know she was offered 5 months, 3 months notice plus 2 months severance. You see at the bottom, she's owed 24 months. That's a 19-month difference. That's how much she is actually owed, even though the company has legitimate reasons for making this move. That's why you have to get advice if you lose your job. She's owed 19 months pay. Chances are, if you lose your job, you're owed a lot more as well. That's why you call me. That's why you go to pocketemploymentlawyer.ca and you do not, under any circumstances, sign that severance letter.
20 cents on the dollar. That is not good. And with that, we are going to wrap for the day. So she will be reaching out for sure. You can do the same. That is 1-855-821-5900. Again, 1-855-821-5900. The email address go to is always help@employmentlawyer.ca. And we've mentioned it several times. We've used it several times. pocketemploymentlawyer.ca. Even before that phone call to Lior, pocketemploymentlawyer.ca. Thanks for watching. We'll catch you next week. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.